contract interpretation. So now that the recording is started, I'll hand it off to Kai.
Thank you. Guess let me start. Okay. Can you hear me? Am I good?
Yep, all good.
Okay, so today we're going to go through, we've talked a little bit about some of the tenets and rules. We're going to go through some more, and hopefully we have 5 or 6 examples. Hopefully that helps with the definitions. So give us feedback if you need more definitions. I think that the key to all of this that we're talking about is every situation has a little nuance that might be different. And it's a matter of taking all these tenets and doctrines and putting it together, because it's not only on the contractor side, it's on our side, and weighing the plus and minuses to reach settlement, basically. So we're going to go through the cause of conflicts and show some of the drawing and specification interpretations and maybe conflicts. We're going to review the general contract interpretation rules and related doctrines. Again, some of it is a little bit of repetitive, but there's a lot of new stuff. And then we're going to go through a few examples. So as we've gone through this series, it is kind of tight. I noticed this presentation, we don't have as many pictures. So if you have questions, just stop us. I'm hoping this can be more of a dialogue. So we're going to go through the contract interpretation rules, look at a little bit of the defective specs, and then 2 key rules tenets is the duty to seek clarification and the duty to inform, proceed, and inspect. So again, we talked about those a little bit before. Duty to inquire, it's all the same. So we have an obligation of the contractor to release information that we know, and then the contractor has an obligation, when there is ambiguity, to ask the question. So those direct ambiguities, if there's a direct conflict and they fail to ask, then favor goes to us versus them. So we have a few examples on that. Okay, so here are the, I think, 10 or more contract interpretation rules. So there's a rule of reasonableness, and I think this is probably the paramount, because when you look at a situation, you have to look at what there's a reasonable person, but in our case, in some of our instances, it's the reasonably educated contractor. If they are in the business and they're not superior, but they're not bad, reasonable, would a reasonable contractor make the same interpretation? And so that is going to be what the courts will look at. So terms interpreted as reasonable, are they objective and intent matters? Subjective interpretations are usually dismissed. So again, they're not going to look at, what it says or what another person, a unilateral kind of interpretation. They're gonna think, what would a reasonable contractor say? And so as we look at this, even talking, maybe we're talking to other coworkers or other contractors, how do they interpret it? That can go into your analysis. The courts will favor interpretations with reasonable trade understanding. So again, they have background, reasonable contractors. So that's what we're looking at. If somebody reads something and would the reasonable person make the same interpretation? Again, we can look at the bid tabs to see if other contractors made a similar interpretation. So we have those tools at we have those tools. Okay, the other part is reading the contract as a whole, which also includes the addendum and the responses to the addendum. So good time, opportunity to read the contract as a whole. Again, the master submittal log that was created with the Excel sheet that you can upload into ACC, and all of this may have changed, but that master submittal log was always the way for me to review the contract, go through it, read it, highlight, tab. That was always the first thing that we did when we looked at the plans and specs, is read the whole thing, including the addendum, looking for those conflicts, looking for the major items of work, and starting to think about how it will be sequenced. So we're going to look for the interpretation of terms in the context. So again, our spec have the definitions. That's super important. Avoid rendering any part meaningless. So in the court's perspective, there are no meaningless parts. If on the design side, or even doing your constructability review, if you feel like something is not really saying anything, then you should probably have a discussion with design, and maybe it should be deleted. So the court is always going to look for meeting in everything in the contract, and specific terms override the general terms. Obviously, that's kind of like the special provisions overriding the general. So number one, rule of reasonableness. Number two, read the contract as a whole. Now, Four Corners is very similar. Interpretation based on only the written document. So again, we're only looking at what is within the contract, the Four Corners. Use prevailing meanings unless otherwise defined. And then there's a 3-step process in looking at, are the terms clear? What is the plain meaning of the terms? If they're ambiguous terms, what was the intent of the parties, and interpreting that? And if there's no meaning, we're not adding external assumptions. If there's no meaning, there's no meaning. So we really look at the terms in the contract and interpret it literally within the contract. So very similar to the previous one. Custom and usage. So this is a big one because it basically is what we've been talking about. Trade customs can clarify meanings or require showing established recognized usage. So this is basically when DOT acts in a certain way, that is the way we're used to dealing with DOT. So even if it is not written, which that's why all of these concepts go together. We have being reasonable, we have looking at the contract, and then we have looking at people's patterns or what their custom and usage is. How do they usually behave? And this is the hard one, because as DOT, if we create that pattern, then that will be counted as, this is the way DOT behaves. And others that may try to enforce the contractor contrary to the behavior, that's when we're going to have that implied waiver. So custom and usage, big thing. Okay. Okay, so parole evidence rule prevents use of prior oral statements to change written terms. Exceptions are when there's ambiguous or vague terms, limited external evidence may be allowed. So again, we're going to look at what is in the contract. We are not going to listen to things. And again, we got a ton of terms here, because then you got constructive changes and things like that. But in the parole of evidence, it is only about what's written, and prevents the use of oral statements, maybe said during pre-cons, things like that. Okay, rule against the drafter. So as the drafter of the document, we are always they're going to take the side of the contractor over the drafter, because we should have known what we were putting out on the street. We should have understood our intent. We should know the conditions. That's part of our obligation as the drafter. So ambiguity is construed against the party that drafted it. So if there is conflicting statements or confusion, it's going to be the contractor. Again, you have to go through all the tests of reasonableness, and is it written in the contract, and does the contract term have meaning, and what is a reasonable person going to interpret? And if all that exists and ambiguity still exists, the contractor is going to have the favor. The last resort rule is an expectation for negotiated contracts between sophisticated parties. So again, there's an expectation that everybody understands the agreement that they're being entered into. Conduct of the parties. So to me, this is similar to the custom and usage. The parties' performance conduct may demonstrate intended meaning. Prior consistent interpretation during contract performance carries weight, and previous contracts with other parties may not apply. So again, if we do something with GP on the Big Island and we do that something differently on Kauai, those are the conduct of the party. Again, I think it's very similar to common usage or custom and usage. Okay, couple more. I think these are the last ones. The Spearman Doctrine, government and owner warranty performance of provided specs. So again, the drafter is expected to understand, know, and warranty that their specs are solid. Defective specs, including impracticalities, material unavailability, or missing information, again, will be judged against the drafter or against the DOT. So it's our responsibility to make sure the specs are buildable, materials available, and that we haven't missed anything. Suitability and availability. Contractor bears the responsibilities for checking that the material is available. So again, this goes back to if we put something out and the contractor knowingly doesn't ask the question, doesn't have that duty to inspect or duty to inquire, then it could be against the contractor. Owner is liable if all specified options fail to perform. So again, judged against the contractor. Impossibility, impracticability. So the contractor excused only when performance becomes impractical and not just more costly. So our plans have to be buildable. So those are all kind of takeoffs in my opinion of the favor, or what is it? The drafter. I got to go back to that one. Rule against the drafter. Okay, so those are all of the rules. And then we're going to go through a couple other things and a ton of examples. And I don't know, I'm not looking at the chat. If there's any chat cord, let me know. Here's a couple other things, constructive and cardinal changes. So we talked a little bit about constructive change. That's when basically you don't have a written order, but the way we behave or the way we have talked about things infers a change. So that's a constructive change. So extra work done without formal order, but implicitly required, could be construed as a constructive change. Must prove the change an owner ordered or fault. That the change was ordered by the contractor or that it was our fault. Not sure I understand the second part. Cardinal change. So that's a constructive change. Basically, it's implied change. We either say something or we imply something. The contractor behaves, and then we come back and say, "Wait a minute, we didn't tell you to do that." And they'll be, "But you did. You kind of said this and you kind of said that." So it's implied. Cardinal change is substantial deviation from original scope, amounts to breach of contract-ish. We're going to go through an example that's a little bit complicated. Okay, so we've got our rules and we've got our other definitions. Here's a couple more. So today is really going through a lot of these definitions and probably repetitive. Okay, duty to disclose. So this goes back to superior knowledge we talked about before. We have a duty or an obligation to disclose. So both the owner and the contractor must share relevant information. This goes back to good faith contracting. We don't enter into an agreement to be deceitful. This is where the False Claims Act, there's a Hawaii False Claims Act, there's a federal False Claims Act. False Claims Act basically says you can't lie to me. Contractor, I had a contractor tell me once it's my job to lie to you. I'm like, no, that's against the contract. It's a breach of contract if you're not being honest. So no duty to disclose equally available information. So if again, if it's a rainy place, everybody knows it's rainy, we don't have to say, hey, by the way, it rains there. The owner's failure to disclose material facts adds that burden or puts the burden back on the owner. So again, when you're looking at these kind of conflicts, or the courts do, or as we're looking at negotiation, did we disclose? Was there superior knowledge? Was it something that was equally readily available? You know, all of these things go into the analysis and consideration. Okay, so again, we've talked about this before, but there's the cost and notification. So contractor is entitled to cost and time adjustments for defective specs. Again, just like anything else, is there entitlement? That entitlement includes that they would be they're allowed to get an equitable adjustment or a change order, which includes idle times delayed, all that increased effort, and they must give the timely notice. So if you don't get anything from this series, I hope it is timely notification, timely notification. Speaking of timely notification, here is the little reference chart that we have. So again, make sure timely notification so that we can all prevent the prejudice against the owner. Okay, so here's the next part. We've talked about this before, the duty to inquire or the duty to seek clarification. So there's an obligation to notify. The contractor must report glaring patent errors, right? So if there's something that says install this and demo this, and you've got two conflicts, the contractor has an obligation to do that, to notify. If they miss it, if they don't see it, it's still their fault. So that again, when we look at the pros and cons of settlement, we have to look at that. Is it something that they should have known? No duty to detect latent. So again, latent or unseen ambiguities, or maybe it's buried. I don't know. Contractor can rely on reasonable interpretation. Again, that goes to our reasonableness. Doesn't apply to clear contradictions, which goes back to the first one. And then there's a two-step process. So the contractor can rely on the reasonable interpretation, but this does not apply to clear contradictions. So was it reasonable or was it a clear contradiction? If it was a clear contradiction, an error on our part, contractor has a duty to seek clarification, a duty to inquire. If they fail that, then again, there's a failure on their side. Obviously, we have a defective plan or contract, so there's a failure on our side. So where do we settle? How does that work? That's what we'll go through in the examples. Okay, so duty to inform. Again, proceed and inspect. We have duty to inform. Both parties must share information. Known design flaws, material limitations. You know, we have tariffs going on right now. I think everybody's kind of, you know, how is this going to affect costs and prices, and has it happened and will it happen? There's a duty to proceed. Contractor must continue to work even during disputes, so they can't just stop work. Well, they can if they're not getting direction, and that's where I kind of like the unilateral change orders or a field order. So you're at least directing them to do something. And the duty to inspect. Improper rejection or an over enforcement may entitle the contractor to damages, or improper acceptance does not relieve the contractor of responsibility. So this is kind of tricky, because even if we inspect something and we miss something, it's still the contractor's responsibility. So pretty heavy on the contractor side. How are we doing on time? Pretty good. Cord, I'm going to pull you in since you wrote most of these examples, and then I'm going to jump in during the interpretation part. I was going to text you. I know I didn't text you about this.
Okay.
Are you ready? Johnny on the spot?
Sounds good.
Okay.
Okay.
Good.
So let's go through a couple of examples here. The first is underground fiber optic communication lines. Again, these are some hypothetical examples that we're taking you through just to present some contract interpretation views, and just taking you through various different ones. So the first one I'm just going to go through with you. Well, actually, first, let's go through. Is there any questions before we go through examples?
Good job. Yes. Are
Yeah.
there any questions? Because there's a lot of material.
Yeah, a lot of definitions, a lot of things that we've repeated.
Yeah.
And just want to see if there's any questions. I know Andy asked where the master submittal log is located. So that is located on the H.Wiki site. We have both a federal and state template. So depending on the funding for your job changes the standard submittal requirements. But obviously, as Kai mentioned before, the special provisions will override that. So even though we do have master submittal log and we have trainings for that, you'll have to go in and override some of the submittals, add some of the submittals as you go through your contract, right? As you read through your entire contract at the beginning, you'll have to go in, add submittals, remove submittals, and all of that. And the great part of this master submittal log template is it's already configured to a way where you're able to import it into your ACC submittal log. So it is a process that you're able to do that review, the contract review, with as little steps as possible. So the submittal logs are located on the wiki site along with the training for that. So I posted it in the chat. I posted the resource page and also the 2 Excel templates. So Calvin has a question here. Should some of these legalist terms be used in field memos and claim responses? And yes, absolutely. So not sure if you want to expand on that, Kai, but
Well, go ahead through the example and then we'll, yeah.
Okay, let's run through some of these examples first. Okay. All right, so first example, we have some background. So HDOT puts out a contract to install an underground fiber optic communications line along the section of H1 freeway in Honolulu. The system is a part of a statewide ITS upgrade designed to remain functional during hurricanes, floods, and also heavy rains. So that's some of the background, and we'll go into the design. Some notes about the design. So HDOT hires Pacific Infrastructure Consultants and engineering firm experienced in utility corridor design. The plans call for fiber to be installed PVC conduit in trenches along the freeway shoulder. So again, we're referencing the specs. HDOT standard specifications, section 718 requires that conduit to be installed in dry conditions. Backfill compacted to 95% maximum density. So we're going to reference this a little bit later. And this 95% maximum density, as you probably all know, is quite impossible to achieve in soil that's saturated. So in the design, it's a dewater as necessary to meet compaction and conduit installation requirements. Let's go to the next page. Next page, guys, sorry.
Oh, sorry.
No worries. No worries. Okay, so let's talk a little bit about what happened during the bidding stage. So the bid quantities show 8,000 linear feet of trenching at $180 per linear foot. So in total, the estimated value of this would be about 1.44 million. One bidder, IFC, submits a pre-bid question. So given that the alignment runs through low-tying areas near the limits, viaduct, will dewatering be required for conduit installation? And then HDOT's response via addendum is no, provided the conduit interior is pumped free of water and free of debris prior to pulling the cables. So again, when we're looking through contract interpretation, we're going through our project during construction, it's important that we reference what happened during pre-bid, right? During the bidding process. So wrapping it all together, the relevant background is IFC had worked on an earlier project in Hilo, just to provide more context, with a high water table. There, instead of dewatering, IFC uses 6-inch to 12-inch of ag base course above the water table, then backfilled with suitable soil. So HDOT had accepted this on the Hilo job, but the method was not written into the current Oahu's project specification. So not written into the project specials. So let's go to the next page. Okay, so now we get to construction. And so once the contractor begins trenching along the Nimitz area, they encounter tide-influenced groundwater, only 2 feet below grade, making dry compaction impossible. So in reliance on that addendum that we just went through on the last slide, and to avoid costly dewatering that the contractor did not bid for, IFC uses the method that they use on Hilo, the ABC aggregate backfill method again, with HDOT field inspector verbally proving during construction. The ABC cost is $250,000, which IFC did not include in its bid. So that's what happened in this example during construction. So let's move on to the next slide. And so now let's take a look at the 2 different positions. So after completion, the contractor submits a claim for the $250,000 in the additional aggregate cost. So now we're going to take a look at both positions, contractor position, HDOT position, and obviously up for interpretation for the contract, but let's go to the contractor's position. The addendum represented that dewatering would not be required, but wet conditions forced them to choose an alternative method that was not priced in their bid. So since this method was necessary to complete the compaction requirements in wet conditions, it was a change to the scope. So that's what the contractor would argue in this scenario. And then HDOT's position, on the contrary, would be, well, the specs still required proper compaction regardless of water conditions. The addendum only addressed dewatering for conduit installation and not for trench backfill. Using aggregate was a means and methods choice. The contractor could have dewatered instead. So I know Kai mentioned in the chat, what are the rules at play here? So opening this up for interpretation. I'd like to hear if anybody has
So
any
we went
comments.
through, yeah, we went through a ton of definitions. And I don't think we sent this out, so it's gonna be hard for you to go back and check it. Maybe I'll cut and paste some of them in our chat. So I'm gonna go through the next one. It has the relevant background. So again, let's just review this because I really want you to think about all the things at play. We're gonna summarize it, and hopefully you start picking up on this. So again, there's a question. So the contractor duty to inquire happened, right? They asked the question, they needed information. Interesting part about this question, which, again, now let's think what a reasonable person would think, right? They're asking if dewatering is going to be required for the installation. But part of installation is backfill, right? So the way they worded it probably could have been a little different. Is it going to be needed for the entire, the entire installation? So that's where we got to think even on the contractor side, on our side, what the responses are, what that could open us up to. So again, no, they're saying no, just put the conduit in, make sure there's no water and it's fine. Okay, but that's not the entirety of installation. The installation, that's putting it in, that's installing, but to complete the installation, you need to backfill, right? So what would a reasonable person say? There's a little bit of me that thinks, okay, I don't know if I would have agreed with DOT's interpretation of this. So again, then there's this other thing, right? They knew they had done this on another project. So we have our, oh, now I have to go back. I'm actually going to cut and paste this in there so you guys have them. There's the conduct of the parties, right? We did this on another project, so we're pretty sure we can do it. The conduct of the parties, and then what exacerbates the conduct of the parties. So they did it in Hilo. They thought they could do it here. They asked a question, so they fulfilled their duty to inquire. But during construction, what does the inspector do? And what is that called? Anyone? Is anyone responding? I'm going to put all these notes in there so you guys have it, since unless you want to try to send out the presentation.
I can say
Anyone,
that.
anyone at all? Okay, there's all the rules. Field directive, yes, Kelvin. So what did we call that? That was where I gotta go way back over here. Constructive change, right? Extra work done without formal order, but implicitly required or implicitly told. Okay, so we've got them inquiring, we have a response, we have a okay, wait, what's this other one? Conduct of the parties, we did it elsewhere. We have a somewhat of a constructive change because the inspector actually said to move forward and that it was okay. Again, the thing that we haven't talked about this is where's the notification? That was my first thing when you see after completion. So IFC submits a claim for 250,000 after the completion of the work. That does not tell me they provided notification, verbal notification in 5 days verbal notification in a day or 3 days, depending on the situation. And then the 5 days they're providing written notification. I don't see that. So notification comes into play. Did they provide notification? And this is exactly why, because they proceeded with the work based on what they were told in the field. Maybe the project engineer said, yeah, go ahead, or sorry, the inspector, but nobody said it was going to cost extra money. We thought, oh yeah, means and methods, it's good, but I didn't know it was going to cost money. So that is called what? What is the other thing called? Did DOT pay for the helo change? Great question. Don't know, but great question. So all these things start to come into play. Where was the notification? Yeah, inspector said it was okay, but I didn't know it was going to cost any money. I just said it was an okay way to do it. So again, we went through these ton of little things at play. So let's go like break it down. DOT project, the majority, this project is to install conduit, right? So when we're installing it along the whole thing, that's the entirety of the project. So if you didn't factor in how you were going to deal with the water, that's a major problem. And I somewhat agree with the ambiguity in the response from DOT. So the addendum said no water as long as the conduit's free, but didn't, again, how do you finish installation without compaction? And if you can't do that and you can only do it through dewatering, then how are you supposed to do it? Either way, there's extra funds, right? So that's the other part of it. Had you responded and said, yes, you got to meet compaction, or you have to meet, so maybe the better response might have been make sure water is free and clear and meet all other requirements of the contract, because then it would have been very clear this is the totality, and maybe they would have come back after that. I don't know, but that's where on design side we should think through all those responses, make sure construction's involved with those responses, because you're the ones that are going to have to deal with this in the field. Groundwater encountered, contractor to use backfill. Again, there was a little bit of a constructive, actually, I think I have it on the next page. So what are the key issues? No dewatering was intended for the installation or for trench work or backfill, which is part of installation in my opinion. And there was a verbal direction or approval to use that. Does that constitute a constructive change? And that contractor did fulfill their duty to clarify, but the wording was a little off, right? It wasn't clear. There's still ambiguity that exists because of that interaction. So the rules that are illustrated, again, would a reasonable bidder think the addendum removed all dewatering requirements? So right now, think through this, right? Custom and usage, contractor relied on prior DOT acceptance of the fill over the groundwater. Conduct of the parties, inspector verbally approved and supported the contractor's interpretation. So again, that could be constructive change. All these things kind of start to overlap. And then reading the contract as a whole, the addendum was included in the contract. So the key takeaway is clear contract language, reading, provisions in context are critical, and reliance on field approval is risky without written authorization. And again, I would throw in here, had notification happened the next day, then everybody would have been aware, hey, this work is happening and it's happening at an additional cost. Because in some respects, I would think it's okay to proceed that way. It's the cost associated with it. And that is what is that called? Did anybody put it in there? Not yet. What do we call that when they take away our ability to mitigate or make change or eliminate? Prejudice. Danilo answered last time too. Yes, prejudice against the owner. We can do the same thing on the contractor side, but again, this is the one thing that drives me crazy about notification, because it might have been okay, and if you proceeded and completed the work, now I can't do anything. I could have maybe, yeah, I don't know what. I could have paid for a dewatering. Maybe dewatering was cheaper than your alternative, but I don't know, because you proceeded and we didn't discuss it. We didn't negotiate it. So that is why, if anything comes out of this whole series, notification, notification, notification. Okay, next example. No, wait, we have another piece of this. Okay, so this is a further analysis. So why is DOT likely to win? Reading the contract as a whole, differing site conditions wouldn't apply because we already know the water table's there. Everybody knew it, right? Not a differing site condition. Means and methods gives the contractor discretion on how they're going to deal with it. The key part is the addendum was narrow. It didn't waive dewatering for all purposes, only for the act of conduit installation. And I would go a little bit on the reasonable, because the reasonable person, I'm not asking you if that's going to affect me putting the conduit, because maybe the conduit floats or I need to keep it down or whatever. But to me, the intent is, do I need it for this entire operation? And that's where on our side, if we just said, make sure you read the rest of the contract, basically, that I'm answering this, but all other contract provisions prevail, or all other contract provisions are still in play. It's like, we just got to think about those responses. Contractors still bore the responsibility to choose a feasible method, aggregate dewatering to achieve compaction. So again, on their side, where IFC could have a chance is IFC can prove the addendum reasonably misled bidders into believing dewatering was unnecessary for any part of the work, and they could argue that that was a latent ambiguity in the contract documents. And I could go back and forth and say, well, if that wasn't clear, then why didn't you ask another question? So again, we've got all of this ambiguity. If the contractor's verbal approval to construction is documented, IFC could claim it amounts to a constructive change, but DOT would argue that the inspector cannot unilaterally modify the contract. So again, taken as a whole, contractor or the inspector is not allowed to change the contract, which is in the contract. So we're at four corners of the contract. We're taking the contract as a whole. So there you go. None of these, I would say none of our examples are going to give you definitive answers. And I think that's the point of this particular class, is there aren't necessarily right and wrong answers. And we'll cover that at the end. But ultimately, we're going to have disagreements. We're going to have, I interpret it one way, you interpret it another. And it floors me when it's so obvious to us and it's so obvious to them, and we have a disagreement. At the end of the day, we're going to have to settle it. Okay, killed that to death. Example 2. Go.
Right. So the first example is quite long. I know we have 20 minutes left. And then these other examples are a little bit smaller and less detailed. So we'll just walk through some of these to kind of paint the same picture that we painted with the first one. Again, there's no right or wrong answer per se. It's up for interpretation. But anyway, so let's go through example 2. So HDOT puts out a contract to replace damaged guardrails along Kalanianaole Highway near Hawaii Kai, and this project involves installing new guardrail posts into existing fill areas along the shoreline. So a couple of background points. Guardrail posts to be driven to a minimum embedment depth of 5 feet. Soil compaction around posts to meet density requirements in the contract. Contractor to remove unsuitable material and replace with compacted fill if necessary. So next. Okay, so again, let's go through pre-bid, taking a look at the pre-bid documents as per instruction. So quantity for post foundations is given as 300 linear feet of excavation / replacement fill. The contractor submits a pre-bid question. Given proximity to the shoreline, will any special foundation treatment be needed for guardrail posts? And then HDOT responds in an addendum, no. No special treatment is anticipated beyond removal and replacement of unsuitable material per the standard specs. So what happens in construction upon starting work, the contractor encounters soft coral fill in multiple locations, and the material then collapses under load and cannot achieve compaction without flowable concrete fill. So then the contractor uses 150 cubic yards of flowable fill, which equates to $85,000 cost to stabilize the posts, which is obviously not included in the bid. So next, this is similar, very similar to the first one. And yeah, just a few
Okay.
summarization. Go ahead.
Yeah, so let's go through the background. So guardrail replacement near the shoreline, no special treatment, right? So DOT says no special treatment, but we run into unsuitable material that requires flowable fill. Again, that's an option. They could have probably done other things. Did the no special treatment mean no work beyond standard specs? What was this specified foundation material suitable for intended use? And then the rules that are illustrated is reading the contract as a whole. Again, what does a contract say if there's unsuitable material? Does it say that that will be paid for? Or does it say that the contractor is responsible? So the specific response, we'll go through that in a minute. And then suitability and availability of implied warranty of material fitness. So again, they said no special treatment was anticipated, but they also did say that you would use standard, if there's unsuitable material, that you would deal with that. So how does a contract say you should deal with that? So Polly's argument is the addendum stated no special treatment was anticipated. They interpret that flowable fill was beyond standard unsuitable material replacement, and this is a change condition. DOT's position is the specs already warn that unsuitable material must be replaced with stable foundation, and the choice to use flowable fill is a means of methods. So the interpretation, if the addendum says no special treatment is stated, is read broadly, Polly could win, right? Narrowly, DOT keeps the risk. So position will go against the drafter, right? We also have that if the courts look at the definitions as defined, you know, when I look at the actual response, which we go back to, no special treatment is anticipated beyond removal and replacement of unsuitable material per standard specs. So then that would take us to, what does it say about unsuitable material per standard specs? Does it say that would be treated as a force account? Does it say that that is, what is it? Not contingent. My mind is gone. That it's part of the contract, that we're not paying for it separately, that it's part of the contract. So it really depends on what those per spec says, right? What does the standard specs say about the unsuitable material? And then the standard specs will control unless the contract explicitly overrides them. That was our response. So we would have to look there. Okay, next one. So these are the short ones. Any questions, put them in the chat so that we can go over it, because I know we're running out of time. Go. We've got 4 more examples.
Did you want to go through these examples still, or should we
Yeah,
go
yeah.
to the cardinal? Okay, so example number 3, HDOT bids a job or bids a project to resurface Route 19 along the Hamakua coast on the Hawaii Island. The scope includes milling of 2 inches of existing asphalt, placing 2-inch of new asphalt, and repairing base failures. So specs require the subgrade to be firm and unyielding before asphalt placement. If base course or subgrade is unsuitable, contractor must remove and replace. No dewatering provisions in base repair section. So again, we're talking about dewatering. Contractor asks, given the rainy conditions, potential spring water seepage into cut sections, will subgrade drying or dewatering be necessary? And HDOT then responds to no. Paving can proceed provided surface is free of standing water prior to asphalt placement. So Kai, one thing before you switch over, there's a reminder thing, a reminder window on the bottom side of your screen. So if you could
Thanks.
dismiss that.
And it won't let me touch it. I can't
Well, if
grab
not,
it.
that's okay. I'll continue. When milling begins, contractor encounters continuous seepage from hillside spring. Water saturates the subgrade, preventing proper compaction. And to meet density, the contractor imports geotech style fabric in 12-inch of crushed rock for stabilization. Again, extra cost, $180,000. And again, we're constantly repeating this, and I feel like this is a very similar situation. But one of the rules is duty to seek clarification. So contractor asked about subgrade drying, but didn't press for clarification on the seepage conditions, right? So it's a contractor's duty to seek that clarification.
Mm-hmm. Okay. Let me answer this. So Calvin asked about the notification. So again, as soon as these things start, notification is key. So you understand there's additional cost. The contractor, I think the other part of that is what is the magnitude of that cost? They have a responsibility to respond, to provide those numbers. That gives you an opportunity to start looking at the contractor or the contract interpretation and looking at the facts and at least moving along with mutual awareness that yes, is the only thing that we have to do and we have to do it and it's going to cost money, so there are decisions that you can make, informed decision, and that's the goal. Okay, so on example 3, so that was to respond to Calvin. On example 3, resurfacing project with base repair, the addendum said paving could proceed free if surface was free of standing water, continuous seepage prevented compaction, and contractor imported geotextile and rock. Key issue was no dewatering. Was no dewatering absolute or only for the visible water? And did seepage make compaction impractical? So the rules that we're looking at, 4 corners of the contract, take the contract as in its entirety, and was it actually buildable? Could we actually do this? Conditions prevent the performance without a major change. So those are the 2 rules at play. Here's the other arguments. So Kohala could argue that the addendum indicated no drying or dewatering was necessary, that wet conditions made it impossible to meet compaction specs without extra material. Thus, this is a change in scope. DOT's position, addendum only addressed surface water before paving, not subsurface moisture in base repairs. Contractor assumed risk for methods to achieve compaction. The broad interpretation favors the contractor, while a narrow interpretation favors DOT. And clarity in the pre-bid questions and written answers could prevent costly disputes. So again, if we went to court on this, what would the reasonable person think? Because in my mind, if it's wet on the surface, it's got to be wet underneath. So when you say don't worry about the surface, there's an implied don't worry about underneath. So I'm a little bit on the broader side, and the fact that favor will go against the drafter. So you're the drafter, the favor goes against you. So I kind of feel like Kahala will win. Example 4, go.
Okay, so HDOT plans a temporary bypass road during rehab of the Wailoa Ridge River on Kauai. Bypass requires construction of a 120-foot reinforced concrete box culvert to carry small stream under the detour road, so foundation excavation must reach firm bearing material. Bedding material to be compacted, granular fill, 6-inch minimum thickness, meeting the AASHTO gradation requirements. Section 206 of HSS allows for dewatering as necessary to place bedding material in dry. So no alternate foundation method described in plans. Next. So again, let's go through the pre-read question. So given proximity to river and shallow groundwater, will cofferdams or continuous pumping be necessary? And HDOT says, based on geotechnical borings, dewatering should not be required. Shallow groundwater unlikely to be unlikely at foundation excavation. So what happens in construction? During excavation, contractor encounters saturated alluvium, so groundwater at above 18 inches above bedding grade, with constant seepage from upside stream. So continuous pumping to achieve a dry working surface and to stabilize the contractor proposes and receives verbal field approval for over excavation and placement of 3 feet CLSM before bedding. So the extra cost with that is 120,000, which again, as most of these examples, not included in bid. So the rule that would apply here, duty to disclose knowledge. HDOT's geotechnical boring suggested no groundwater issues, but if prior knowledge existed of seepage in similar location, non-disclosure could be an issue here. So that's something to know. Next slide.
Yep. So the key background: bypass road box culvert geotech report said shallow groundwater is unlikely. Excavation revealed saturated alluvium, pumping failed, and verbal approval was given for over excavation and CLSM placement. Again, we didn't put in the notifications here, but notifications should have happened. Everybody knows there's an issue. Did inaccurate geotech information breach design warranty? Can verbal approvals change obligations? And the rules in play here are the parole evidence rule. Verbal approval cannot override the specs, so that goes to the verbal part. And the Spearman doctrine, owner responsible for defective design information. Again, contract favors the contractor or goes against the drafter, all of those things. So what are the two arguments? Contractor's argument: addendum represented dewatering would not be required. The saturated alluvium was materially different. Remember, materially different from borings. CLSM was beyond specified bedding material, and this is a differing site condition. Inaccurate geotech data made specs unworkable. Specs always require a stable compacted bedding layer. Choice of CLSM was a means and method decision. Groundwater at the location is foreseeable given proximity to the river. If the addendum is as a factual representation of the site conditions, no dewatering contractor could win. If it's read as an opinion or limited in scope, DOT keeps the risk. So again, I feel like the majority of these, the favor goes against the drafter. The owner provided design data carries implied warranties, but contractors should still verify critical conditions. And in this situation, I feel like they asked the question, the response came back, rely on the geotech. And the question really becomes, was CLSM required? Was there some other way to do it? And, having that, the inspector talking about whether that's okay, again, it's probably okay. The question is whether we want to pay for it and whether we should be paying for it. So making sure that notification happens and that conversation happens so it can happen immediately. Okay, 2 more examples.
Okay,
3
yeah, so
minutes
2 more
each.
Well, I would say 2 more examples. The last one is a different example. This one is very, very similar to the one previously reading boring.
Do you want to let's skip this
yeah,
one?
let's skip this one and let's go
Okay.
to the cardinal change example.
Okay, so the last one is a cardinal change. So some people may know this project. The original project scope replaced with completely different project, cardinal change. Contractor, so my big question, contractor accepted the change and proceeded without timely detailed pricing, updated schedule or subcontractor or vendor coordination. There were also COVID area shortages that drove major cost increase for material and labor. At project close, contractors sought reimbursement for all costs, but costs were hard to separate between owner costs and contractor inefficiencies and mismanagement. Oh my gosh, what a mess. So it's cardinal change, entire scope 100% different from the bid. Is this a breach or just a large change? Timely notice and cost proposal. Did the contractors delay in submitting prices prejudice the owner's ability to mitigate? Duty to mitigate. Who bears escalation costs when delays prevent timely procurement? So again, if somebody could have procured something and a year later it costs more, is it the owner's fault or is it the contractor's fault? Cost separation without clear records. How do you determine which costs belong to the owner and the contractor, which is why notification is paramount. External impacts, again, shortages in our day and age, tariffs, those kind of things. Okay, so the rules at play, cardinal change, work outside the original normally requires a new agreement or renegotiation, which renegotiation happened, but it happened incrementally. And that was the difficult part because it happened and then we would proceed and then we wouldn't get things and we had to do unilateral change. So it was a mess. Constructive change, proceeding under direction without formal change order. So again, we knew there was proceeding, but without the cost, it prejudiced our ability to mitigate or look at alternatives. Duty to provide timely notification. Late proposals can bar recovery if they harm the owner. And again, it's hard because if the entire contract is different and you're proceeding, it is paramount to make sure you get those notifications as well as costs so that you can mitigate costs where possible. Duty to mitigate. Both parties must limit damages once aware of the changes or delays, and impossibility and commercial impracticability. Severe market disruptions can justify or relieve if documented. So what are the takeaways? Owner position, contractor delayed in pricing, poor scheduling and prejudice mitigation efforts, costs inflated by the contractor's own inefficiency are non-compensable. So I know it's written in the force account, we don't pay for deficient work. Lack of timely notice could bar parts of the claim under contract clauses. The contractor position, owner fundamentally changed the project. All resulting costs should be paid. External price escalation beyond contractor's control and documentation may show impacts directly tied to the change. Everything's a change, right? So everything's tied to it. Key takeaways. Never proceed on a cardinal change without a formal scope, schedule, and agreement. And if you know your director, that's not really going to happen because he wants it done, right? So you're in a predicament. Timely and detailed cost proposals are critical. Protect entitlement. We asked and asked and asked and we didn't get. So at some point we're like, we're not going to pay you. We're not going to pay you. We have to start telling them that. Maintain records to separate owner caused delays and contractor inefficiencies. And again, the key to that is notifications because we knew the contract was extended, but we thought it was their fault. And because there was no notification that it was our fault, then again, you're like, well, I thought it was you. And so now you have to solve it, right? So negotiating changes is a responsibility of both contractor and the owner. If they want to settle, they'll ultimately will, but the path depends on entitlement. Is there contract or legal right to recover? The settlement approach, how will you reach those terms, and a timeline? How long will negotiations or disputes continue? So potential outcomes, some contractors will litigate or threaten to sue. Resolution may require strategic decision-making on DOT's part, administration, construction engineers, consultants, and staff. Why documentation matters? You have to document every issue, even minor ones. Memories fade, people leave, money runs out at the end of the project. That's when everybody starts getting desperate. Detailed records are critical when disputes are decided months or years later. Reaching agreement is critical. Clear documentation obviously will help early negotiation, realistic compromises to protect all parties and help avoid costly drawn out disputes. We have an event, we provide notification, we make sure we're documenting, we negotiate, and we settle. So this slide was meant to, at all the examples that we provided, There's plus and minuses. There's no right answer to this. There's no right answer. So that's where changes are, the responsibility of both parties. So we do our best, we document where we can, we establish where there's entitlement, and we move forward through the process. So closing point specification issues are major sources of conflict and cost. And I would say not even specification, communication, what things look like, how they're interpreted. Everybody is an individual. They all have their individual interpretations. And if you're in construction and you think you're going to have a project that doesn't have disagreements, you're in the wrong profession. Important to have clear, customized contracts. We do the best we can. There's always going to be ambiguity. Try to avoid it in reusing templates so that every contract you're looking at the facts of that work. Okay, done. 1 minute over. What is the question? Just wanted to add a note from the contract side. Maybe in best interest of the owner to place things outside of the scope of the project when there are unknowns, and they set up force accounts to cover or address thorough claims. If contractors are expected to cover all things that could happen, the bids would be heavily inflated. Yes. So that happens as well, and sometimes that makes it outrageous, but again, we come up with the best we can. Any questions? I know it's a lot. We tried to go through various examples, and I think bottom line with this session is to understand the various tenets. Everything really goes to reasonableness. I always think it goes to reasonableness. If there are no other questions, we're out of time. Want to thank you again. Email. I guess we're using Econ now, but email us or put chat if you have questions. Yes, I know that was Calvin's saying every project should have miscellaneous field adjustment force account. I know that was a big one with art. I mean, we can talk about it. I think it's the ability to define that, how big is it? Yeah. It would be a new pay item. Okay. If there are no other questions, thank you guys. And we'll hang out for a little bit. If there are now there's everything. If there are quantity disputes, but contract docs note contractors responsible for their own quantities. It's moving. Let me see if I stop sharing, I can go back to. I don't know. I can't see the chat.